Good morning. Happy Thursday. So Lane Meyers had the second half of his bond hearing. The court found that the proof was evident, or the presumption was great, that Meyers had committed a felony while out on pretrial release for a felony. And based on that, under Rule 7.2 of the Arizona Rules of Criminal Procedure, the court found that they couldn't release Lane Meyers on bond. So a couple things about that. Number one, that's a variation on the I told you from the beginning, that, like, generally speaking, you're going to look at one of two things. Is he going to run, or is he a danger to the community? This is Arizona's a little variation on the danger to the community thing. If you commit a felony while you're out on a felony, then you're a danger to the community while you're out on pretrial release for a felony. If you commit a felony while you're out on pretrial release for a felony, you're a danger to the community. That's kind of their twist on it that I told you might be there. Again, I am an attorney. I'm a licensed attorney. I'm licensed to practice in California. I am not licensed to practice in Arizona, so, take everything I say with a grain of salt. I told you that I would have bet he would probably get a bond condition, but I wouldn't be shocked if he was denied bond. Well, he wasn't denied bond, or he was denied bond, and I'm not shocked. The defense counsel, I know that Lane Meyers' little sycophants were thinking that the defense counsel was just terrible from the previous day's hearing. I mean, there's people who get their idea of what attorneys do or are able to do from watching movies. People who liken themselves to Tom Cruise and their ability to act like an attorney, like Tom Cruise acted like an attorney. Well, I mean, you're delusional. An attorney is limited by the facts and the law. Now, an attorney is more likely going to be able to articulate the facts in a way that is beneficial to his client, and to articulate the law in a way that's beneficial to the client, and make distinctions about things in a way that's beneficial to the client, more than a pro se or a pro per person would. But they're still bound by the facts and the law. So, like, if the facts are against you and the law is against you, you pound the table and shout like hell. But that's it. That's like the extent of what you can do. You have to remember that in the A Few Good Men movie, well, number one, that would have been under the UCMJ, which is a different system than the systems that are run by the states, and you have fewer protections, et cetera, et cetera. But even in that movie, you have to remember that the defendants were defended by attorneys and the prosecution was attorneys. So there was attorneys on both sides, and, one side is going to have the facts and the law on their side and the other side isn't. And normally, in every case, one side has more of the facts and or more of the law, and the other side has less of the facts and or less of the law, but still some facts and still some law on their side. So usually it's not all the way. It's kind of like, somewhere around that. It's there. Usually you can make an argument. Usually you could point at facts, but one side is going to have more facts and or more law on their side. And that's what happened in this case. The defense attorney, I thought, made an excellent argument at the end. I thought his argument was like, I am shocked that a defense attorney who is not a private defense attorney, who's an appointed defense attorney, made such a good argument. And he did a really good job. His argument was great. The way he laid it out was great. His attempt to distinguish, this is the date that the minute order was filed, and so that's the date it went into effect. And Lane Meyers didn't know the exact terms of what were going to be filed until they were filed, and he didn't make any videos after that time. I thought that was an excellent job, excellent argument. The problem is, the prosecution made it was a solid argument. It wasn't excellent. It was good. It was good. It was serviceable. It was workable. It was a workmanlike performance. It wasn't exceptional, but solid. The problem is the judge reviewed the evidence. That's the problem. That's the problem. The judge reviewed the evidence. The judge looked at the things that he did and were like, yeah, this violates the restraining order. So therefore it's felony harassment. You can't, like, I'm sorry for all the people who think that because you don't have to watch Lane Meyers videos, that somehow it's not stalking or not harassment to put out her publicly available information. Guess what, folks? It is. It is. I'm sorry. It is. His intent was to harass her. It's pretty apparent. And he did, in fact, harass her. I mean, after he put this out, people called. It's pretty apparent. You know, and I'm sorry that the people who are in the pro Lane Meyers camp don't understand the law. But again, you might want to take, I'm not biased in this. You may think I am. I'm not. I didn't want Lane Meyers to go to jail. I didn't want him to have his bond denied. I'm not that guy. I'm just looking at these things and I'm like, yeah, it's probably harassment. He's probably going to get convicted. He's probably going to get convicted. I'm sorry. I don't want the man to go to jail. I don't want anybody to go to jail. I don't want anybody to go to prison. You know, I'm looking at this and I'm like, all he really did was put her contact details for a workout. And he called her but you know, I personally, John, the person, don't think that the potential sentence is warranted by his actual actions. I don't think that. But the state of Arizona disagrees. They've put that sentence out there, and they've defined harassment to include what he's done. Like, his odds of getting convicted are very high. And I know you don't like it, and I know people are trying to. I've heard the world's dumbest arguments by Lane's supporters. The world's dumbest arguments. Oh, you know, nothing that was said was a threat. Well, they played the voicemails, dude. They played the voicemails at the first bond hearing, the first no bond hearing. Those were threatening. Like, people are like, oh, he just contacted her. She's a state actor, and he contacted her to receive state assistance. No, bro, I heard the voicemail that he left. The people have heard the voicemails that he's left. He did not contact her for assistance. He contacted her to harass her. Like, I'm sorry. It's patently obvious. It's patently obvious that he contacted her to harass her. He should have had no contact with her, period. He should have never contacted her. If he had never contacted her, none of this would have happened. So I'm not a huge fan of him getting no bond. I'm not a fan at all. There is a silver lining to the dark cloud, as it were. His ability to harass her has diminished dramatically while he is in custody. I don't know if Arizona does this. A lot of states, I know California gives you like extra credit for time served pre-sentencing. So, you know, if you don't get bonded out, the time you are in jail accrues at like a 2-to-1 ratio or whatever. You know, every place can do it differently. I'm not saying that Arizona does this, but likely he's at least going to get credit for time served. And it might be extra bonus credit for time served. You know what I'm saying? So there's that. And it's very difficult for him to harass her while he's in there. So, you know, that's the silver lining. The downside is that every communication he makes with anyone other than his attorney will be recorded and will be reviewed. It's not a maybe recorded and a maybe reviewed. Everything he does will be recorded, will be reviewed. Everything he says can and will be used against him in court. It's already been used against him. There was one silent video that he posted on his channel, apparently going through the University of Arizona contact information list for the various staff members. And one of the questions was, like, how do you know that he did this? And the detective was like, yeah, he admitted to it in a jail call. So it's not hearsay. If Lane Meyers says it, it's not hearsay. It's a statement by a party opponent. Anything you say can and will be used against you. They notify you ahead of time. Those are being recorded. So, like, bro, like people are like, he's a genius. He's 14-0 or 16-0 or whatever. Like, unless you count his losses. Unless you count his losses. I mean, it's just tragic. Like, it's tragic that the guy thinks he's smarter than he is. He thinks he knows more than he does. And he's causing himself to suffer. And I feel bad for him. And I would like for him not to suffer. I would like for him not to be in jail. But I also would like him not to harass random women on the internet whose sole crime in Lane Meyers' eyes is to be married to someone who is, in Meyers' eyes, doing him dirty. Like, this isn't how normal people react. This isn't how rational people react. This isn't right. And the last thing, I'm going to leave you with this for today. I want you to pause it on this for today. I want you to think about this for today. People on Lane's side are thinking it's okay for Lane to go after the alleged victim because she is a state employee, because she works for the University of Arizona. She's a state employee. And so she's fair game. She's a state actor. She's a public official and everything like that. Well, let me ask you this. A federal law clerk working for a federal judge is a federal employee. If you do the same exact analysis, she is a state actor, a federal actor. She's a government actor. The same analysis that you guys want to use for the alleged victim, you can use on Lane Meyers' girlfriend. So everything that was done to her should be protected by the penumbra, the umbrella of free speech, right? Right? But no, you take offense. You're like, how dare they get our gal fired because she's fucking Lane Meyers. So she's got to be Theotokos. But fuck this other bitch who happens to be married to the guy I don't like. I want to get her fired. You fucking ignorant assholes. You hypocrites. Anyway, I'm going to get down off my high horse. In conclusion, it sucks that Lane Meyers was denied bond. There's a silver lining. He won't be able to harass, or it'll be very difficult for him to harass the alleged victim. And he should be earning credits at a more than 1-to-1 ratio for time served. The hearing was fair. The defense counsel did a great job as far as I could see. Other attorneys have stated that they thought the defense counsel did a great job. The problem is the evidence. The evidence is what damned Lane. The evidence is what screwed him. Lane's own actions that Lane recorded and put out there for the whole world to see are what screwed him. Lane screwed Lane. It wasn't the judge. It wasn't the prosecutor. It wasn't the defense attorney. Lane screwed Lane. Lane is solely responsible for Lane currently being behind bars. And everyone on Lane's side is completely hypocritical because they are upset over a federal employee getting allegedly fired by the alleged victim. But they're perfectly fine trying to get the alleged victim fired because she's a state employee. Go fuck yourselves. Have a great day.